What does fishing, three-letter agencies, and gun rights all have in common? Well, today we're going to go over a little-known case called Loper Bright Enterprises vs. Raimondo. The outcome of this case could change the legal landscape of the entire country when it comes to the ability of three-letter agencies like the ATF to make regulations. We'll be taking a look at how one case in 1984 became one of the most cited cases in American administrative law, and how the federal agencies have abused it to govern by executive authority. Hey guys, I'm Tiffany and you're watching One in the Chamber, the show that helps you become a better pro-gun activist. Before we get into this video, of course, please like, subscribe, and share to help us defeat YouTube's algorithm. On May 1st, 2023, the Supreme Court accepted a little-known case, Loper Bright Enterprises vs. Raimondo. Currently, oral arguments for the case are scheduled for January 17th, 2024. So we'll be starting the new year off in 2024 with a major case that could effectively change the way that regulatory agencies like the ATF are able to create rules like we've seen in the past with the pistol brace rule and more. To understand the scope and impact of the Raimondo case, we'll first need to look at two different things. The first thing is Magnuson-Stevens Fishery Conservation and Management Act. Second is a legal principle called Chevron deference. Now stay with me, I know this sounds like it's about fishing, but this is way bigger than you think. After we lay all the groundwork, you'll have a much clearer picture of how this case affects gun rights and how it could end up restricting the ATF. So let's start with the Fishery Act, as that's the basis for this case. In 1976, Congress passed the Magnuson-Stevens Fishery Conservation and Management Act into law. The law itself was enacted to assert control over foreign fisheries that were operating within 200 miles off the U.S. coast. But a provision of the law is that the National Marine Fisheries Service may require fishing boats to carry federal monitors on board to enforce the agency's regulations. This is where the problem starts. In later years, the budget for the Fisheries Service started to fall, but the need for monitor coverage was growing. The Fisheries Service was put in a bind. They couldn't afford to pay for the increased coverage in the North Atlantic region that was needed to maintain their surveys and studies. Well, to fix the problem, they did what all government agencies seem to do these days: administrative rulemaking. In doing so, they identified an area in the law which did not explicitly say that the government couldn't make the private companies pay the salaries of the federal monitors. So in February of 2020, the National Marine Fisheries Service published its final rule establishing a standardized process that would require industry-funded monitoring in all New England fisheries. In response, Loper Bright Enterprises, which is a family-owned herring fishing company operating in New England, sued the National Marine Fisheries Service in the United States District Court for the District of Columbia. Loper Bright's argument was that the existing law, the Magnuson-Stevens Act, did not authorize the Fisheries Service to force private companies to pay federal monitors. You'd think that the court would see this and say, yeah, the government is out of line here. But of course, you'd be wrong. The court sided with the National Marine Fisheries Service by using a legal doctrine called Chevron deference. Okay, so what's the Chevron deference? The Chevron in Chevron deference refers to the landmark 1984 decision in Chevron USA versus National Resources Defense Council. Chevron is considered to be one of the most important decisions in U.S. administrative law. It has been cited in thousands of cases over the past 40 years since the decision. But how does this work? If a law is ambiguous, the doctrine requires the court to evaluate if the agency's interpretation of the law is reasonable or permissible. If the agency's interpretation is deemed to be reasonable or permissible, the court must accept the agency's interpretation of the law. In practice, administrative agencies like the ATF can essentially govern as lawmakers. They create rules and regulations based off of existing law, then use Chevron to justify their rule change as reasonable. This doctrine is how the ATF is allowed to say that pistol braces are legal for years, and then on a dime suddenly change course and change the legal status of 40 million pistols overnight. There's a reason that GOA has submitted a brief in support of Loper Bright. It's because the outcome of this case directly impacts on how much or how little the ATF will be allowed to harass gun owners in the future. So back to the case at hand. By using Chevron, the lower court in Loper Bright Enterprises vs. Raimondo determined that the Fisheries Service reasonably interpreted the law, as there was no clear language about the costs at sea monitoring in the law. And on November 10, 2022, Loper Bright petitioned the Supreme Court to hear its case. In the petition, Loper Bright asked two questions. The first asked the court to rule on whether the lower court properly applied Chevron when granting the fisheries service the power to force private enterprises to pay salaries of monitors. Secondly, they asked the court to rule on whether Chevron should be overruled outright or limited in scope. The Supreme Court granted the petition, but limited to only the second question. Seems like the Supreme Court may have an issue with Chevron. So how did I infer that? Well, in 2022, Justice Neil Gorsuch wrote that Chevron deserves a tombstone no one can miss. Justice Clarence Thomas has said similar things as well. In 2015, Thomas wrote that Chevron rests from courts, the ultimate interpretive authority, to say what law is and hands it over to the executive branch. What's also interesting is Justice Ketanji Brown Jackson heard the case at the circuit level, right before being nominated to replace Justice Stephen Breyer on the Supreme Court. What's awesome is that it forced her to recuse herself from the case. She would have likely supported the tyrannical bureaucrats anyway. We'll have to wait and see what happens with the oral arguments, but it looks like the Supreme Court might actually be ready to put Chevron to bed. This would be a huge win for gun rights advocates everywhere. Stopping the ATF from getting away with whatever interpretation of the Second Amendment or congressional statute they get from their monkeys on typewriters in the basement would be a massive blow to their power. This would also stop the sneaky anti-gunners from petitioning the Biden administration from pushing their gun control through the White House. Instead, having to go up against the patriots in the House and Senate, like Rep. Massey, Rep. Roy, and Senator Lee, and the countless others who have our backs. What this means is that agencies like the ATF will have much less power to interpret and make law through regulations. Anyways, that's it for today, guys. I wish you all a Merry Christmas, a Happy New Year, and I'm looking forward to seeing many of you at SHOT Show.